Hey guys, I'm here.
Hey,
Sorry, I had to run out to the field today to locate some pipelines.
looks like it's getting warm out there. What I can see.
Hello, everyone.
Hello?
Hello.
Hello.
Okay. We ready to begin? Looks like we're recording.
Yes, we are.
Okay. Welcome, everyone, to the City of Oklahoma City's Board of Adjustment meeting for September 3rd, 2020. The meeting is disconnected at any time. The meeting will be stopped and reconvened once a connection is restored. If the connection is unable to be restored within 30 minutes, the items left on consideration will be rescheduled to the next scheduled meeting. The agenda and documents are located on okc.gov. For anyone wishing to speak on an agenda item or to speak under citizens to be heard, hopefully you've already reached out to city staff by phone or email, and I'll call on you at the appropriate time. We will call a case, and then I will recognize the applicant or representative to speak, and then I'll recognize any protests, and then we'll close with the applicant speaking. The board can ask any questions, and then we'll deliberate, and then the board will vote. If you call in after your item has been heard, you'll be allowed to speak under citizens to be heard. We ask that you limit your comments to 5 minutes. When you call in, staff will mute your phone or your device. I ask that all participants except for board members keep their sound on mute until they're recognized to speak. To unmute your phone, press *6, and on the Zoom meeting, press the space bar or click on the microphone icon. Please do not interrupt board members as they're speaking. Please remember to only have one person speaking at a time. I'll remind staff to make sure this meeting is being recorded, which it looks like it is, and I call the meeting to order. Can the clerk call the roll, please?
Mr. Merchant,
Present.
Asbury,
Sorry about that. Present.
Privet,
Present.
Voorhees,
Present.
Ybarra.
Present.
Okay, Chair, we have our quorum.
Okay. First item on the agenda is to receive the minutes from the August 20th, 2020 meeting. Do we have any changes or a motion?
Make a motion to receive the minutes.
Second.
Okay. Once you get the ability to vote on your voting pane, please cast your votes.
Waiting on Mike.
I don't have a voting panel, but I'll second it.
Alt tab.
Mine is not showing either.
So when the meeting went live, hopefully everyone pushed escape because it goes full screen automatically. So
Got it.
Oh. Didn't know that. Thank you.
sure. If you press escape and then try to find the proper window, it should
Got it.
be visible. Okay, great. And I think just waiting on Mr. Voorhees.
Pressed escape. I don't have a voting pane. Shows I seconded it.
Okay. Well, if you want to verbally do it, staff, can we?
Got it.
Oh,
All
okay.
right.
Okay.
Popped up. Got it.
Yay.
And it's approved. The next item on the agenda is continuance requests or withdrawals. I think we have one.
Have one item request for continuance today. It's item 6,
case 14774. The applicant requests a deferral to September 17th.
Okay. Was there anyone on the line that was hoping to speak on that item? Hearing none, I think we're ready for a motion.
I move that we continue the case as requested.
I second.
Okay.
You want me or Kitty?
Oh, I thought I hit it. I'm so sorry.
No, I'm just, it don't matter.
Got it. I'm sorry.
Okay. Got a motion and a second. Once you're able to, cast your votes. And it's approved. The next item on the agenda is consent requests, which I don't think that we have any, which means the next item is items requiring a separate vote.
All right, first item for public hearing is item 1, case 14768. It's request of Gregory Pearson for a variance to the rear and side yard setback to allow a swimming pool and accessory building at 7201 Ridge Manor Lane.
Is the applicant on the line?
Yes, sir. I'm here. Can you hear me okay?
Yes. If you want to just start by introducing yourself by name and address and then presenting your application.
Yes, my name is Greg Pearson. I live at 7201 Ridge Manor Lane. We moved here about 2 months ago and tried to move a pool in that into the property that we bought, and we thought we had plenty of room. After investigation and finding all my pins, I found out that the property layout that you guys have on file is not correct to what actually I have laid out on the property. This drawing that you have in front of you here is where I want to put the pool. I want to go 20 feet away from my property line, which I'm asking for the variance for the 5 feet. That'll put me about 2.5 feet away from my porch in the backyard here. With the house not being in the exact same spot as it was per the plot plan. The plot plan shows the house being 40 feet from the build out line on the very front of the house. It's actually 117 feet from the property line, not 40 feet. So the house has been pushed back a lot further on my property than what I thought it was per the building plan. So the 20 feet off the easement is where I'd like to put the pool, starting it, and then it'll finish it approximately 2 feet from the concrete that I have back here in the back. It'll be about 4.5 feet from my back porch. And then I'm also looking to, at a later date, to put a shop in to the left of the house there. I'm asking for a variance to push it as close as I can to the property line so that I can put a 30 by 40 shop there. I can't push it back any further because of the back line, because of the utility easements is back there. And I also have a well that's 30 feet off the property line back there also. But it'll put it approximately 2 feet away from the property line. And it'll be on the side of my house and in the backyard of my house right there.
Okay. So if you could just summarize the amount of feet each variance request is.
So the variance request in the back easement is the 5 foot. Basically, it's going to be 25-foot variance that I'm requesting. But I'm requesting basically to be able to be a 5 foot variance that I'm requesting there off that utility easement. So 20 feet is what I'm requesting back there.
So that one's going to be a 20-foot setback, so 5 foot variance. Is that correct?
That's correct. 5 foot variance.
Okay. And then on that shop?
On the shop, I'm requesting to have a 2 foot variance or from the property line itself. And then it would be approximately 15 feet into the side yard. So it'll be going past the front of the house, the back side of the house.
Okay. I guess there's nothing, JJ, on here about the pool being so close to the house that needs a variance?
No, it's fine.
Okay. I think, given the part of the city that this is in and that abutting AA land that we can see on this map, I think I'm okay with this, given that, but I'm only one kind of board member. We can open it up to the other board members for questions or comments to the applicant.
Is there a fence possibly on that south line?
Yes, sir. There's a fence all the way around the property there, sir.
Okay.
So it will be fenced in completely.
Do we have any protests?
It's going to be my next question. I don't have anyone signed up, but is anyone else on the line that wanted to speak on this case? Okay, hearing none. One other question. I guess this is an above ground pool.
Yes, sir.
So were you wanting a variance forever or for a certain number of years, or?
I didn't really think of that. Probably in at least 10 years, I would guess. I don't know how long I plan on keeping it.
Okay. And board members, I don't know if you care about, maybe making that a 10-year variance on the pool or not. I don't have strong feelings either way, but.
I don't plan on moving, I'll put it that way.
Okay. All right, board members, any other questions, comments, or a motion?
I'll move approval on both variances, no time limit.
I'll second.
Okay. Got a motion and a second to approve the variances in case number 14768 for the reason they meet the statutory conditions for variances. Once you get the ability to vote, cast your votes, please. And the variances are approved. All right, thank you, sir.
Thank you.
Next item, number 2, case 14775 is a request of Lucretia Henderson for a variance of the side setback in the PUD 902 district at 9308 Armand Drive.
Yeah,
Is the applicant on the line?
yes, David Box, 522 Colcord Drive, here on behalf of the applicant. This is a request for a variance to the 5-foot side yard setback. This is an existing house that has been in place for several years. And there is an individual that is seeking to buy the house. When they went to get title for it, it was discovered that there was approximately a 5 or 6 inch encroachment to the 5-foot side yard setback. It's unclear how this happened, presumably some sort of error in the field at the time of pouring the foundation. So we're seeking relief from that. Again, it's very minimal. I think we're 0.3 feet away, so about 5 or 6 inches from meeting that side yard setback. When you drive down the street, I would challenge you to be able to look at it and say which house violates that 6-inch prohibition. But I think it's consistent. It is fenced in, and no one knew about it until the time at which somebody went to get a title opinion to buy the house. So we're seeking the relief. Staff has found no unfavorable considerations, and we'd ask for your approval.
They hired you, David, for 0.3 feet.
The title company was very clear. They wanted 5 people from this esteemed board to say that it's okay.
What do you think, Ms. Ybarra? We make them tear the house down?
Not today.
Okay, she's feeling generous today, Mr. Fox. So.
Good.
I can get on board with it. I don't have anyone else signed up to speak. Board members, any questions, comments, or a motion?
I'd like to make a motion that we approve case number 14775 based on the fact that it meets the statutory requirements of the variance.
I'll second.
Okay. A motion and a second to approve the variance in case number 14775. the reason that it meets the statutory conditions for a variance. Once you're able to, cast your votes, please. And it's approved.
Thank you.
Thank you.
Item 3 is case 14779. It's a request of Zach Woods with Gardner Studios for a variance to the front yard setback regulations of the DBD district located at 700 Northwest 4th Street.
The applicant on the line.
Yes, sir. Zach Woods is here.
Okay. You want to just give us your address and present your application?
Yes, Zach Woods with Gardner at 323 Northwest 9th in Oklahoma City. I don't need to take more time than I need to. Just a very simple asking for a variance only as a reaction to an existing utility easement that is on our property. That utility easement is a 15-foot easement existing from on the back side or our side of the property line. Therefore, we can't build closer to the property line than 15 feet. The maximum distance for our building setback in DBD is 10 feet. So we're simply asking that we can gain this variance in order to not have to have all the utilities relocate and vacate that utility easement.
Right. Made sense to me, and I'll note that Downtown Design Review gave a recommendation of approval on July 16th. Recommended that we approve the application. Board members, any questions or comments? Okay, and I think we're ready for a motion.
Move approval.
Second.
We have a motion and a second to approve the variance in case number 14779 for the reason it meets the statutory conditions for a variance. Cast your votes, please. And it's approved.
Thank you for your time, everybody. Have a great day.
Thank you. You too.
Item 4 is case 14776. It's an application for a renewal of a special exception for Blake Gatewood to allow home sharing in the Historic Preservation District at 1429 Northwest 38th Street.
The applicant present.
Applicant is present.
Okay. You wanted to introduce yourself again and give your address?
Yeah, so I'm Blake Gatewood. I am the primary resident of 1429 Northwest 38th Street. I came before this board about a year ago and got a 1-year extension to use a portion of my home as a home sharing or Airbnb. We have done so over the last year, we believe successfully and respectfully, and we wish nothing more than to continue to do what we've been doing. We followed all of the rules over the last year that were laid out for us. I know some of the neighbors, I'm reading the PDFs here that are attached, and I'm seeing some accusations that we weren't home all the time, or maybe we were using it for prostitution or something, I think is what it was implying. I can assure you that neither of those things are the case. As far as I knew, there were actually no complaints about it up until this meeting ramped back up. Over the course of the whole last year, no neighbor has ever approached me. I was approached by one neighbor who actually told me that, they opposed me at the last meeting, and they told me that they'd had a change of heart and actually thought it was a great idea. I think that it just went really smoothly. I mean, there were, 2 cars at times, but that was what was allowed under the rules you all set out for me to follow. Most of the time, I think there were actually 1 car or no cars. I had the opportunity to host some of the neighbors, and some of the neighbors in our neighborhood had family members coming in town, and they wanted them to stay close, so I would put them up in the Airbnb. And overall, it was just a really great thing for our family. It was a good supplemental income. We had fun with it, and never felt that there was anything bad going on in there or that it was any way a danger to my family. We actually just had a third child, and obviously we would never do anything that would put our family in danger. So based on the fact that we believe it went so smoothly over the last year, we want to request an extension, and I would actually like to request an extension that is well over a year and to the full extent the regulations would allow, and the reasons for that are really twofold. First, I think, just the fact that this year went well is evidence that I'm able to do what I'm proposing in a respectful manner that does not in any way jeopardize the historic nature of this neighborhood, which is what this, this code, this Oklahoma City zoning code was designed to do. There was a language inserted specifically to apply for historic preservations. And I believe because I've shown that it's not going to affect the integrity of the historic nature of this neighborhood, and because the Historic Preservation Board has now recommended twice that what we're doing is in line with all of their rules and regulations, I believe that we should be granted an extension to the full extent, which I believe is 10 years. I'd be willing to accept a little bit less than that, but that's kind of what I'm going for. And really the main reason I want this, and I'm even asking for it, is because I believe that what we're doing is respectful of our neighbors. Obviously it concerns some people, and it's an odd thing for some neighbors, and I understand that, and I still want to be respectful of that. But I think that there are some neighbors and some people in Oklahoma City, just at large, that might never agree or get on board with the idea of Airbnb at all. And so I don't want to have to come before this board every single year and cause a big fight in my neighborhood, because it really is polarizing. There's meetings between neighbors who are for it and who are against it, and it's just this whole big thing, and it's not going to stop. Next year when we come, if you gave me a 1-year extension, we would be here again, and my neighbors would all be getting flared up again. And I hate that, not because I just want to push and get my way, but I hate being the cause of all of this discord. And I think that if you granted me an exemption that was for a lot longer period of time, people would become more accepting of it, learn to live with it, and it wouldn't be this thing that flares up discord every single time I have to come before you again. And that's all I have at this point.
Okay. I will note for you that no one who's come here on a special exception application has gotten 10 years. And no one in an HP has gotten even close to 10 years. So I'll tell you that kind of right now. I'm not in favor of anything close to 10 years for this, assuming it gets approved. I'm only one member of the board, but and I can be outvoted, but that's kind of where I am. I appreciate your concerns about kind of re-agitating these issues every year or something, and trying to avoid that. I understand that, but I can't go on board with 10 years or anything close to that. I'll just kind of get that out there.
Can I speak to that just really, really briefly?
Sure.
So my thought on that is just that under the zoning code, someone whose primary residence they're using, if I wasn't an HP, I would be able to use an Airbnb as long as I followed the ordinances. I wouldn't have to come get a special exemption from you guys. But because I'm an HP, the whole purpose is to preserve the historic preservation district. And if I'm showing that I can do that, then in my view, I'm in exactly the same shoes as any other person in the city who's not in historic preservation. Because even if you gave me a 10-year license, at any point in time, if I'm not following rules or if I'm not doing things in a way that if I'm trying to do something that affects the historic nature of the district, I'm gonna get called out and my license is gonna get pulled. I mean, it's not like if I don't follow the rules, it can't be revoked, So that's just my thought is I see myself as in exactly the same shoes as any primary resident in the city because I have shown that I can do it in a respectful way of the historic preservation.
Well, I mean, you would, just to address that, you would still need a special exception if you're elsewhere in the city. The only thing,
Primary residence?
if you're, the difference with HP is if you're not going to be there at the time, then you also need a variance. But unless you're grandfathered in, you need a special exception. And I get that point. If it's not your primary residence, then that might change things. But you're an HP, and that was hotly disputed issue at City Council. HP was, and so I understand your point of saying if I live somewhere else, things would be different. But the fact is that you don't. And so unfortunately, you have to deal with these issues that come up. That's not to say I don't support your application. I mean, I think that you have demonstrated that the sky is not falling just because you're doing home sharing. I agree with you that there are a lot of these fears early on that people had that weren't really substantiated, and sometimes haven't been substantiated after a year or so. And so, I can support your application because it seems like you've, complied with everything that we've said. My only issue is with the timeline. I'm not on board with the long-term thing. And that's also before I hear from some of the protests. So maybe some of the protests could change my mind. But when I first read your application, even the protests seemed like most of them were saying they just didn't want the conditions that are in place now to change. But they weren't necessarily opposed. But in any event, board members, any questions or comments?
This is Kitty. I would like to support what Chairman Merchant just said, because 10 years is a long time, and I'm not aware of any length of time in that endurance. So I'm willing to support it, but at a lesser time limit.
Okay. Do we want to talk about a time limit now, or do we want to wait to hear from the neighbors?
I think go for 2 years, maybe. Just.
Yeah, I think maybe we wait and see what some of the other commenters have to say, and then we can.
Yeah.
Yes.
I'll make up my mind here in a little bit.
Okay. I think I heard from city staff that they have the ability to identify the next speakers that are signed up. But if there are no other questions for the applicant, we'll move on to the next person that signed up to speak. And I will let Cindy take over on that front.
We had Yolanda Post. I think she needs to hit *6 to unmute.
Yeah, I did unmute.
There we go. We can hear you. Welcome to the meeting. If you want to identify yourself by name and address and give us your comments.
Okay, well, esteemed members of the Board of Adjustment, we are the direct neighbors of Blake and Mary Gatewood. Actually, we look into their property that we are discussing here. My name is Yolanda Post, and my husband's name is Jan, and we live on 1435 Northwest 38th Street. We are both retired educators, and we love to live in a historic preservation district that we helped clean up and make safe over time, because we live here since 2004. The reason to speak about this special exception is that I would like the renewal to be limited to 1 year only. Because the new apartment that they created is used for other purposes than simple lodging, and the host is not always present as required by the ordinance. The ordinance 599350.38.1, that ordinance. The host has to be there all the time when guests are present. I asked at the council meeting of Tuesday, August the 4th, 2020, for a real estate tax moratorium for the properties located next to and directly opposite Airbnbs. Airbnbs affect the safety of their neighbors and the enjoyment of their property. The owners of the property, Evan Blake Gatewood Jr. and his wife Mary, were given a 1-year special exception in August 29, and they got this immediately after buying the house in May 2019 for what was it again? $320,000. They when you gave this permission that they could get this limited this limited thing to do an Airbnb, they changed the interior of this beautiful old house. It was built in 1923 by putting in a dividing wall and a kitchenette to construct a new apartment that was not there when they bought the place. At that time, Mr. Gatewood mentioned to me that he wanted to make also the backyard into a paradise for his guests, hot tubs and all that kind of stuff. And he told me that he loved to play the host. But I doubt that he has much contact at all with his guests. The entrance of the apartment, the rental payment, they charge $100 a night, and the cleaning crew, they are all organized by computer. The apartment is rented almost 7 days a week. 7 days a week, we get new people in. And the direct, or there is not good direct oversight by the host. By the host, of course, that's a great business model, that you get your money without doing too much work. In the ordinance that I just mentioned, the 59, it is stated that the property shall be the host primary residence, and that's what it is. And actually, I enjoy the kids very much indeed. But it should also be occupied by the host at the time of rental. Only the last few months before the renewal requirement, this requirement was followed, and the Gatewoods were present. But the 9 months before that, we often observed that they were absent during the weekends. The guests, we noticed, the guests are not vetted properly. During the week, more serious persons are visiting, and they usually come, they arrive in one car, and apart from all that loud door closings and the talking late at night, their presence is bearable. It is the weekend that is the problem. Usually, the guests in the weekend arrive in 2 cars, and often they seem not to know each other. And more rowdy behavior is the result.
Ms. Post, your time's running out here, so if you could kind of summarize your comments with any.
Sorry. Well, we therefore respectfully request to limit the renewal of the special exception to 1 year, so Mr. Blake and Mary Gatewood can prove themselves as true host of the Airbnb, because they also we can show that they are not there, because one weekend a lady arrived there that was inviting how do you call those guys? Gentlemen callers, and they were not there, because I went to the place on Sunday afternoon when this lady of the night showed herself, what they never do, but she opened the blinds, and I noticed for the first time that was happening in that apartment. I went in the evening when she left, because I was afraid for the customers, I must tell you. She left, and immediately afterwards, around 5 o'clock, I went to their apartment to discuss this with them, but they were not there, so I couldn't discuss it. Then, of course, the next morning, I called the police, and I said, well, is that allowed? Can you just rent out your apartment in the Airbnb to this kind of customer? And he said, no, you cannot. But you have to tell us about it. Well, if I tell on Sunday what is going on there, and the police is coming, I can expect a drive-by shooting. This is what I just want to tell. that I love the Gateswoods, really I do, but I want them to actually protect me and my safety, and also their own. But if they are not there, they cannot protect me. That's what I respectfully ask you, to give them only 1 year so that we can check that they are really trying to not vet this kind of people visiting their property.
Okay. Thank you, Ms. Post. And Cindy, if you wanted to call the next speaker.
We have Suzanne Broadbent.
Okay. Ms. Broadbent?
Yes. Am I unmuted?
Yes, we can hear
Can
you.
you hear me? Okay, thank you. Well, there are other neighbors here who are in closer proximity to this particular property, and they will make their case about the specific things that Ms. Post has brought up. I wanted to just very briefly keep some general ideas before the Board of Adjustment on Airbnb or home sharing, as it's called, in historic preservation neighborhoods. I was part of the group that worked for several months on coming up with an ordinance. And we got as much as we could. I remember on your first hearing, which was on this particular property last year in an HP district, some of the frustration that was expressed of not getting too many guidelines from the city council. And I can tell you, the city council did as much as they felt they could. And you've probably heard this too from other sources, because Airbnb was not particularly cooperative and always threatened preemption to go to the legislature, which they've done in other states. So I appreciate your sensitivity to our historic preservation concerns, although you didn't get many guidelines. And I've noticed that you've put in some guidelines maybe yourself on an informal basis, and I do appreciate that. I wanted to keep before the board specifically today the issue of the contributing property, the main house, you might say, being an Airbnb. The garage apartment, those kinds of things are not a huge concern for most of us. But when we do start moving Airbnbs into the main houses, that's where our concern really gets noticed. And this one does. And that was my objection last year, and it's my objection this year. And I just ask the board to keep that in mind on this and other applications, that when we are talking about the contributing property, and this one it was built in 1911, and it has it's a beautiful old house, that does affect and can affect greatly the ambiance of the neighborhood and the property itself. I would say, I'm heartened to hear that generally the board does not give long-term special exceptions. 10 years is a long time, and the problem with the ordinance allowing 10 years is this special exception runs with the property, not the owner. So Mr. Blakewood can make all the assurances that he wants to, but if he sells the property, he's no longer in charge of what happens there. And someone else will be, and they will inherit that special exception. And that's a concern, and we appreciate your noting that. I would just defer to my neighbors who have worked, I think, with Mr. Blakewood on some ideas on how limited it should be. Our neighbors do not get all hateful and stirred up and concerned over this. We didn't this time. And I believe the neighbors have tried to talk with Mr. Gatewood, and may have, to come to some ideas and suggestions for some of the curtailment of what could be some of the uses. License pulling is not easy in one of these things, and that is not really something that we should say, well, if he doesn't do it right, his license can be pulled. That's a fairly complicated process, and I don't even know that it's been tried yet. So we need to get this right going in. And that is really all I wanted the board to keep in mind was when you're talking about a contributing property, it does raise the stakes for historic preservation. Thank you.
Thank you.
Zij zegt het goed, ja.
Cindy, I think that's all I saw that we had signed up to speak, but it sounds like we might have some more. So if you had anyone else, certainly feel free to call on them.
I have no one else that has pre-signed up to speak.
Okay. Is there anyone else on the line that wanted to speak either in support or opposition to the application other than the applicant? Okay. Hearing none, Mr. Gatewood, if you wanted to respond to any of those comments.
Yeah, thank you. I would just say in general, regardless of the length of time the board grants me, the rules remain the same. I mean, and I have no plans to sell my property, but even if it did get passed on to someone else, they would have to follow those same rules. And if they didn't, then the repercussions would be suffered. I think I definitely understand neighbors' concerns, and I get it, and I want to be respectful of those concerns. And obviously, I'd be willing to take less than 10 years. I think I really think even 2 years would be too short. When my concern is this discord. I mean, I've had a handful of guests who have stayed come to me and say they've been approached by neighbors who are trying to talk them out of staying at my place anymore, telling them they're not welcome to stay in this neighborhood anymore. We don't like Airbnbs around here. And I think a longer period of time makes some of that go away. I think there has to be a length of time that makes people accepting that, this while it may be regulated and while there are rules in place, it can still be done. I think that the concerns are mostly just that people don't like Airbnb. And I think granting a 3 or 4 year extension takes care of me having to come before you again and stirring the whole neighborhood up again and again, and neighbors talking to guests and all of that kind of stuff. I think tempers will cool down, and I don't think anyone's angry at me. We come here and we kind of fight with each other about this stuff, but we're all still civil in our neighborhood, and I love the post and I love my neighbors. It's just we're kind of put in this awkward position where we have to oppose each other on this thing. And so I think a 3 or 4 year extension would soothe some of that turmoil in the neighborhood in the long term.
Okay. Board members, any questions or comments of the applicant before we discuss?
Man, I'd say, unfortunately, living in HP, I think it's a thing that you're going to have to deal with for the rest of your time, because they're a pretty outspoken group. So
I'll just say too, Mr. Gatewood, that while it may be a convenience to you to not have to come here and do this, and as you say, stir your neighbors up, it's there's another side to that, which is that the neighbors don't have an opportunity to come and express their they don't have a forum to do that. And so I have a concern about that reasoning, but I'm ultimately on board with what Mr. Merchant said earlier, and I think Ms. Asbury and Mike also, that I don't oppose your application. I think that Airbnb is the way of that things are going, and but I would also be reluctant to grant a 4 or 5 or something like that term for this. I did also have a question, if none of the other board members did. There were some concerns by one of the neighbors about you and your wife not being, or the owners of the home not being present when the folks are there. I just wanted to give you an opportunity to address that.
Yeah, I mean, I don't really know what else to say besides assure you that, you know, I don't know if my neighbors are under the impression that I have to be there every second there's a guest. I mean, there are times where we're going to the grocery store to eat dinner with family or that kind of thing. I don't know if I mean, I definitely don't think that that's a violation, and there have been times when I do that. If I'm going out of town, I can assure you, we are blocking off that weekend and we are not renting it out. There have been many times where we turned down money on a weekend because we knew we were going to be out of town. And you know, I don't know if maybe we're gone for part of the day and you know, we aren't seen passing through. I don't know, but I assure you we're following those regulations.
And I agree with you. I don't think that the code requires that you kind of sit in the other room looking at the tenants and watching them every second that they're there. You know, I don't think that it requires that. But you know, it does require that you stay there, you know, that you're there while they're there generally. And it sounds like by your representations today that you are. So I'm comfortable with that. I think you've shown your neighbors that you can successfully do this. I think a lot of the concerns are generally opposition to home sharing in general, and people just not wanting it in Oklahoma City or not wanting it at HP, which we've said several times. City Council could have made that happen, and they didn't make that happen. They allowed for it to happen in narrow circumstances. I think HP needs to be the most narrow circumstances. I personally have a keen eye on making sure that these types of uses don't change the character of a neighborhood. So if you start getting a bunch of Airbnbs on your street, we're gonna have some serious problems. But you have a kind of the benefit of being the first in there with it. And so, you can kind of have a little bit of comfort on that fact alone. But we are keeping an eye on whether a lot of these start popping up in a certain area and it starts to not look like a neighborhood anymore. It starts to look like a quasi apartment complex or a hotel complex or something. So those are my thoughts. I can get on board subject to the restrictions that are already in place. And it doesn't sound like there are any new restrictions that need to be put in place that I can think of. Obviously, there's criminal activity, and the police will deal with that. That's not really our role. And I think your permit and special exceptions are at significant risk if something like that does happen. I don't know if it's automatic, but there's certainly a substantial risk if there's criminal activity going on. But that's not for us to decide today. I could get on board with 2, maybe 3 years, depending on where the rest of the board is. I understand your argument about not wanting to rehash this over a short period of time. But at the same time, the argument basically is my neighbors are so concerned and upset about this that I just want to blow those concerns out of the water by having a 10-year special exception. And to me, it's unfortunately for our purposes, I understand for your purposes, that's what you want, but for our purposes, I think we want to see you in here kind of regularly and keep an eye on these home sharing and HP districts. And so I'm in favor of a shorter period of time, but I could get on board with longer than we initially gave, which is a year, because you've demonstrated that you can do it successfully. So, 2 to 3 years for me is kind of where I am, but I'm open to what the rest of the board thinks.
I'm thinking the same, 2 to 3.
I could get on board with 2.
I would have to echo Monica, 2 for me, only because the 2 women stated 1-year terms themselves, and you're asking for additional time, which if you get 2, that is an additional time frame. So therefore, my support would be for 2 years.
Okay.
Approval with the same conditions as before for 2.5 years.
We love you, Mike.
I just want to make sure with city staff that there's not any problem with the half a year. I mean, I will say, Mike, we generally try to do a full year just because it would coincide with our permitting process, which I think is just for 1 year and not for 6 months or anything like that. But
I'll withdraw that motion and move approval subject to the same conditions as before, but for 3 years.
Second.
okay, we have a motion and a second to approve special exception in case number 14776 for a period of 3 years. Once you have the ability to vote, cast your votes, please.
I'm not seeing mine. Oh, there it is. Sorry.
And it's approved.
Thank you. I really appreciate your time. I am kind of curious, how many other HP individuals have come through this process like me?
It's there aren't very many. I think maybe three or four tops, but there aren't very many, and they've slowed down a lot with the COVID stuff. We've been seeing a lot less of these home sharing applications for obvious reasons.
Yeah.
But there aren't very many.
Okay. And I will say, Mr. Merchant, just to kind of speak to what you're saying about taking over a neighborhood with Airbnbs. I mean, if you look at a map, so if you get on Airbnb's app and you look at the map of all the Airbnbs in Oklahoma City and you look at a neighborhood like Meseta Park, there are Airbnbs throughout that neighborhood. And, you know, I think that the historic neighborhood of that, or the historic character of that neighborhood is still intact. So I just want to make that comment just on a kind of broad scale point, but
Yeah,
I really appreciate you guys' time.
Sure, I understand. I'm just letting you know we're keeping an eye on that.
And I get that.
A lot of those were grandfathered in because we haven't seen a lot of those from Meseta Park, but I know there are a lot over there. But it's just and it's more so kind of street by street or block by block. If we start seeing someone that buys a whole block of properties and tries to turn them all into B&Bs, we have some problems. But you know, just voicing that, it doesn't prevent your application. So, all right, thank you.
Thanks again.
Item 5 is case 14771. It's an appeal of Vicky Van Stavern of an administrative determination of a city official regarding the applicable height restrictions for a property located at 1100 South Robinson. David Box represents the applicant, and we have staff, planning department staff from the Riverfront Design Commission, if you have any questions from them. And that's all.
Okay. Mr. Box, if you wanted to present the application.
Sure. David Box, 522 Colcord Drive. The applicant is also on the line with us. As Mr. Chambliss said, this is a bit of a unique application. You know, before you, this is in your capacity as an appellate board, essentially. We are asking you to essentially reverse a decision of an administrative official. The decision that we're asking you to take a look at today is what is the minimum height requirement on this particular piece of property. Oklahoma City, as you know, has a host of different design districts, especially in the core, and within those, you've got multiple overlay districts that exist. So this particular piece of property is zone DTD, but then has the SRODD overlay, and specifically within the SRODD, it falls within the Western Gateway. And so if you look at the materials we submitted, and I trust that you have both our notice of appeal as well as our supplemental brief and support, where we go through this. One thing I want to point out, if you look at the staff report dated July 2nd, 2020, and this is the staff report for the Riverfront Design Committee, the staff makes no mention whatsoever of the height requirements specifically notated for the Western Gateway District. The staff jumps straight to the height requirements in the DTD2, in which it is 2 stories or 30 feet. I'm not sure why they don't make note of that, but they don't. The analysis is void of that. And so if we go then to the provisions that regulate the Western Gateway under the SRODD, what you find is there is a provision that deals with what to do in the event of a conflict between the provisions. Clearly, the staff had to consider what would happen with a conflict when, at the time of inception of all these overlay districts and zoning districts for downtown, we were going to have so many different things going on that there was just bound to be a conflict. And so in our supplemental brief at page 2, it's under the sub B of the SRODD conditions, and it says, should a conflict exist with the underlying zoning district regulations, in this case, that would be the DTD2, and the SRODD, the overlaying district regulations shall supersede. So the overlay district regulations should be those of the SRODD, specifically for this piece of property, the Western Gateway regulations. If you go to that table, and it's table 13500.5 of the SRODD Western Gateway District Standards, what you see is under minimum height for commercial uses, which is what is proposed here and made clear by the staff report, there is no minimum height requirement. So in other words, we could build the single-story structure that we intend to build. They could have certainly, within this very specific area, the Western Gateway District, provided for a different height standard. They could have provided for 2-story, 3-story, 4-story, whatever they wanted. There are certain areas in downtown that have those minimum. Here, they chose, when they were legislating what the proper height should be for the Western Gateway District, to have none as the minimum height. Because of the provision within the SRODD that when there is a conflict between the underlying and the overlaying district guidelines shall supersede. In our opinion, staff was in error when they analyzed this application based upon the DTD bulk standards and not specifically the Western Gateway District standards. I believe this to be a very straightforward case, that when you look at the ordinance, you need to look no further than the language itself under the SRODD to tell us that the overlay must supersede, therefore there is no minimum height requirement. That's what we're asking you to do today. There has been no adjudication on the merits of the application. This is really a threshold issue before we go back to the Scenic River Committee to figure out what is the proper bulk standards to apply for staff to analyze the application. I'd be happy to answer any questions.
So the first question I might have started before you got into your argument is a standing question. I think I know the answer to this, but you're appealing a staff report, a non-binding staff report that gave a recommendation to the committee, but the committee hasn't really decided anything yet. And so, if you could just make me comfortable with kind of the standing issue and talk about that for a second.
Sure. Well, so staff has made a determination, right, that the DTD regulations are what govern this site. And because of that, yes, it hasn't gone for adjudication under the Scenic River. Staff's analysis is DTD governs the site, and therefore when they produce their staff report and it says this proposal does not comply with the development regulations of the downtown design zoning ordinance as follows, they're not making an analysis on the actual bulk standards that actually apply. And so it becomes extremely problematic and almost impossible to go prove a negative at the Scenic River that in fact, well, staff was wrong in the first place, and they didn't even analyze the section of the code that applies to this site. And so what we're appealing is staff has made a determination that it is the DTD standards and not the Western Gateway District regulations that govern here. And so we need some guidance from the board under this provision in the code that allows the appeal of the administrative official.
Kind of a related question. Well, before I even get there, have you talked to staff about this?
I did, and I think Laura Griggs is on, and I don't want to speak out of turn, but I think Laura would tell you that she likely wants this to be decided too. I think staff has long kind of struggled with what to do here. The ordinance is clunky at best, but to me, at least in this portion of the SRODD, it gives us direct guidance on what to do when there is a conflict. And here it's the overlay district must apply. But I do see that Ms. Griggs is on the line, but I believe they would think that this would be helpful too for the board to cast judgment on.
Yeah, I'm just a little bit hesitant. I'm sure you followed the Michael Flynn saga, and how that's basically the government wanted to dismiss charges against Michael Flynn, and the judge said, "I want to have a hearing first." And the government and Michael Flynn immediately went up to the circuit court on mandamus and tried to say, "Circuit court, tell this trial court judge that this is the way the law is, and then they can make a decision." And they won in the 3-judge panel, and then en banc they lost. And the circuit court said, "No, the trial judge needs to make a decision first, and then you can appeal that decision." And that, it seems kind of similar to what's going on here. It's like you're telling us to go tell the committee what to do before they've even made a decision yet.
No, so the nuance is we're not telling you to tell the committee. We're telling you to tell staff what the proper standards are for them to analyze in this application. Because our problem is to go through the process, we're going to end up right back at you on an appeal. And again, the threshold issue is staff even analyzing the right bulk standards? My position is they're not. And the ordinance to me is very clear. It doesn't even seem to be up for debate. When you read the provisions in the ordinance, it clearly says that the overlay shall govern, not the underlying DTD. And so here, when staff is making a report based upon an analysis that is contrary to the code, it makes the applicant's job very difficult at the Scenic River, and even more difficult when we get to the Board of Adjustment on an appeal of the Scenic River, because there is not even an analysis of the Western Gateway District standards in the staff report.
Yeah, I understand that. I'm just kind of expressing a concern and a hesitation that I had. At all these kind of committees that you can bring appeals to the Board of Adjustment, every time you get a staff report that you don't like, you just come up to the Board of Adjustment before having the committee here. It just seemed like we're putting the cart in front of the horse a little bit. And I worry about that, what that means for the future.
No, I understand your concern. This one feels a little different. This may not come as a surprise, but I am often in disagreement with where staff goes in their staff reports. But here, it's different. It's not the conclusion they reached. It's they're reading off the wrong sheet of music, right? And so I'm not really taking issue with their analysis. What I'm saying, they didn't even analyze what they're supposed to analyze. And so in my mind, we don't even really have a staff report on our application. If it'd be like them reading from, the city of Moore's ordinances don't allow this. Well, that's great. We're not within the city of Moore. So it's really a threshold issue before we can even get to committee.
Yeah, and I understand. I think you can raise those exact arguments to the committee and say staff was wrong, just like you always do. I mean, not always, but in the times that you disagree with staff,
understood.
You tell the committee you disagree with them.
So this path was suggested by staff and the city attorney's office.
Okay. Getting to the merits, then the issue I had on the merits is under 13500.4 district use regulations, which is the section that you cite in the brief. You cite subsection B, which is, and it talks about a conflict. If a conflict exists, then you go with the more specific regulation. But that's for conditional uses. It's specifically subsection B. And the only reason I say this is you're making a technical argument, and so I have to analyze it technically. You're citing subsection B, which is for conditional uses, and this use is not conditional. This use is under subsection A, standards for all permitted uses. This is a permitted use. And so that language about the conflict doesn't apply to this case.
Sure. But, even if we go to A and it says standards for all permitted uses, all uses permitted in the underlying zoning districts are permitted subject to the regulations and guidelines of the Scenic River Overlay Design District and individual design districts. So that still points us straight back to the same bulk standard table of the Western Gateway.
Yeah.
So I think A or B gets us to no minimum height requirement.
Yeah, I understand the argument. It's subsection B is just more clear about a conflict, and subsection A isn't as clear about a conflict.
Yeah, correct. It doesn't say conflict, except it does say that there are subject to, and not, it's not permissive, it's subject to.
Yeah. Board members, any questions or comments of Mr. Box before we talk to staff? Okay. I saw that we had some staff from the committee on. If someone from committee could kind of give us their thoughts on this, I'd greatly appreciate it.
This is Laura Griggs. I'm Associate Planner with the Planning Department, and I am the staff planner for the Riverfront Design Committee. And I wrote the staff report in question. From my perspective, when I looked at that, I was looking on one set of regulations being more restrictive and not necessarily in conflict. And from that perspective, I felt that the most restrictive, which is DTD2, would apply. And that is why that is why I chose that discussion for my staff report. And I don't know if there's more you want me to go into, or do you want to ask me questions about that? I did consult with legal before I wrote my staff report, because we do have a legal representative on the Riverfront Design Committee. And I discussed it with her before I did write that staff report.
Okay.
And hang on just with my end, just a second. I think and I don't know if Katie Friddle, who is supervisor of our division, I think she's having some audio problems.
No, I'm here, Laura.
There she is.
This
Okay.
is Katie.
You wanted to go ahead.
I just wanted to add, I just wanted to clarify one thing, and David can correct me if I'm wrong. My understanding is that the appeal is specifically of the determination that a variance is required, because that's a decision that staff makes to say that, yes, you need to seek a variance for this, not just that we don't like the staff report, we don't like the way you, you know, picked and chose which regulations or guidelines to emphasize. That the appeal is specifically because staff said a variance was required for a one-story building. I shared the concern that we don't want people appealing staff reports left and right just because they don't like the angle that staff took, but the specific issue of whether or not a variance is required was what was at issue here.
Yeah, and that's correct, because again, it's a threshold issue. I mean, if you agree with me and agree with what the ordinance says, there is no minimum height. Now, the Scenic River could still deny our project, right? They could still believe that we don't meet certain guidelines, but a variance either is or isn't required. And under DTD, it would be. Under the Western Gateway, the overlaying ordinance, it is not. Our single story would at least meet the minimum height. Now, it's up to debate. We'll have to go figure that out, whether or not the balance of the project would meet those guidelines and get the approval of the Scenic River. But the height is the threshold issue.
This is Laura Griggs again, and just to clarify, there is currently a project that has been approved by Scenic River. So what they're considering now is a revision to that project. So if they were to deny the current project, the original project would still have the approval. And in that case, it did call for the reconstruction of the second story. But so they're revisiting this project because of change in the design.
And I understand why Laura went down the path she did. I don't find any language in the ordinance that tells us that if there are two provisions that exist, the most restrictive should apply. To the contrary, here, I think it's very clear, either subsection A or B. A tells us that it's subject to the regulations and guidelines of Scenic River, which gets us to the table. Or, B, conditional uses, when it specifically talks about conflict, it says the overlaying. So I think both of those point us to 13,500, the bulk standard table that say there is no minimum height requirement.
It's in, I don't know if it's in this subsection, but it is throughout this portion of the code that talks about the most restrictive, regulations shall apply. But to your point, it's not in this subsection. In this subsection, we've got subsection A that says subject to the regulations and guidelines, and then subsection B, if a conflict exists, then you go with the SRODD. So I understand, but I think maybe that's where the more restrictive language came from. Is it is kind of sprinkled throughout.
Sure, it's clunky. I agree. Like, some of them flow really well. Some of them don't. Here, I think we do have very specific language pointing to the Western Gateway District bulk standards.
This is Katie. I will say our interpretation of that point was that because the scenic river language said none, we took that as that ordinance essentially being silent on a minimum height. And if it's a conflict, if they had said 1 story or 2 stories and downtown said 3 stories, 4 stories, that we would have perceived that to be a conflict. But because the scenic river language said none, we interpreted that as being silent on the matter of a minimum height, and therefore that the one that remained in effect was the one for downtown. I realize that none, that language could be much more clear and much more decisive, but that was staff's evaluation of the two.
Yeah, I thought about that as I was reading it and reading the interplay between the two, as that being a potential issue. But there's also the obvious argument that there was intended to be no height, regulation there, which is Mr. Popp's argument. Board members, any questions or comments?
Do have a comment because for me, it seems like there's a lot of conflicting, unclear information that's going back and forth. Because again, it seems like I heard that they're awaiting approval for the project to be approved that may affect whether or not that 2nd story will be built. And also it seems as though they're dealing with a lot of variance in the language that has been spoken about from 2 or 3 different sources, which is very hard for me to follow whether or not we're granting or not granting a variance, or if we're deciding on whether or not that appeal is correct. So I'm a little bit confused. I'm just going to tell you.
Sure. This is confusing. The Board of Adjustment, unfortunately, is this statutory creature that the legislature decided is this kind of, everything that falls over the cup gets sent to you guys, right? So you get all of these appeals and these weird issues. And so what we're asking you to decide is that a variance isn't required. We can't move forward at our case at the scenic river until we know whether or not a variance is required. A variance is required if you don't agree with me. A variance is not required if you agree with me that the language in the ordinance is specific in that the Western Gateway District bulk standards govern, and therefore there is no minimum height requirement. That decision is going to allow the scenic river to move forward with their application, and whether or not it's just a CA application or if it's a CA plus a variance. We believe it should just be a CA application. Still, we'll have to meet all the regulations and guidelines of the scenic river. This height issue is just a threshold issue of what the application actually is. I hope that answered your question.
It cleared it up some. However, I'm still a little bit concerned whether or not the staff is in full support of what you're asking, because it seems like there's some hesitancy in that as well.
Well, and on these appeals, I mean, I'm really putting this to you as if you were a judge. I'm asking you to almost make a legal determination as to what does the ordinance require. And so, staff, I think staff is just really kind of giving you their thought process on their staff report. But what I'm asking you to do is to cast judgment on what does the ordinance require here. Appreciating that this is a very strange provision in our ordinance that allows us to appeal these administrative officials' decisions to you, and you get to sit in judgment of their decision.
And again, you did say that it does meet the requirements.
I'm saying that has nothing to do with your decision.
It does with me. Yeah, it does.
Legally, it
If it
can't.
meets it, it does.
Well, no. The merits of the application are not before you. We have to go get approval from the Scenic River. So what we're building, what we intend, it has nothing to do with your or with your consideration. None at all. Mr. Chairman, do you agree with that point?
Yeah. I understand now why staff wanted you to come here first and all that, and how it's probably not going to lead to a slippery slope of everyone appealing their staff reports to us. I assume you probably also have to pay the $1,200 for the application for a variance. Is that correct? If it's determined, yeah. And so right now it's, their current application in front of the other committee wouldn't really have anything to do with us, unless we decide that there's a height requirement of 2 stories. And then you guys are trying to not do that. And so you need a variance for that. In which case we need a recommendation from the other committee, and then it would have to come before us. So we're not deciding any of that today. We're just deciding whether that provision that would even apply to his application that would require the height requirement. And he's saying it's not, and staff is saying that it does.
Yeah, because you assume that the height requirement's off the table. Assume we meet all the regulations of the Scenic River. When we go to get our CA, presumably we'll get approval. You'll never hear anything about this case again. It's just whether or not we have to get a variance. We believe we don't. We believe the ordinance to be clear in that. Staff read it a different way. And so it's this awkward scenario where we're asking you to cast judgment, but keep blinders on, and the underlying case, what we intend to do, has no relevance.
Yeah. I mean, my opinion, I think you need the variance and move on to Scenic River and let them decide. This area, man, we want this to develop like anything but what's there now. It's going to, because the park's getting ready to be built, but this is not a nice part of town currently.
I don't disagree, but when you say that we want this area, with all due respect, we presumably means the legislative branch of this city sought to see fit that the Western Gateway District bulk standards had no height requirement. So what we wanted, the city, was no height requirement on this specific piece of property.
I'll chime in with my preliminary thoughts. I was highly troubled by this in reading the application and worrying about the slippery slope, and not being totally convinced that city staff was off the mark here. That said, I can get on board with the appeal. It makes sense to me that subsection A, which is where I think we fall, does say subject to the regulations and guidelines of the Scenic River Overlay District. There's some ambiguity there, admittedly, about what none means whenever you're talking about height requirements, but I think that means they don't particularly care about height requirements. And that is the more specific interpretation.
Right, as long as they approve it.
Right, as long as everything else gets approved, they don't particularly care in this district about height requirements. And so that, I understand the counter argument to that about 2 stories being more restrictive and therefore that applying. I understand all that stuff, but I think I agree with the appellant. It's a phrase I am reluctant to utter, but I agree with David Box that on this appeal, that I think there's not really intended to be a height requirement here. So I don't think that they would need a variance, and I would grant the appeal.
And I would really like to thank Mr. Box, as well as you, Chairman Merchant, for clarifying what was dizzy in my mind, because I truly had a hard time with this when I read it the other day. So thank you both very much.
Process that you as a Board of Adjustment member are put in on, it's easy, I think, to understand the appeals of a decision of one of the lower bodies, but the appeal of a administrative official is just it's a very different process that exists in the ordinance. It's an important process, but it is different.
Thank you.
Mr. Box, I had a quick question for you. I'm looking at that statute as well, that says subsection A. Can you address the last part of that that says unless it's specifically prohibited within the section or the design district? I see what you're saying, that it's subject to the overlay, and that then it says unless it's prohibited by the design district. Can you address that?
Yeah, so when you go, I think what it's referring to, if you go into the code, there are additional use regulations for the scenic river. And you see a code, it's 13500.1, and it lists out all the different design districts that it's referring to, and there are X's on certain uses. I think that sentence is talking about certain uses.
Uses. Okay. That's kind of what I was thinking in my head, but I wanted to make sure. So I think it's saying unless the use is prohibited by.
That's my belief.
The only other
Lost
thought might be if the board wants a
design district. Okay. Thank you.
If the board wants a like a legal opinion or something from the municipal councilor, it's going to stop the project up a little bit. But if the board's not comfortable voting, we could request something like that. It's a very close call for me, but I can get on board with it, particularly to kind of keep the wheels moving on this whole thing. I definitely don't want to see appeals like this very often, but I do think it's going to be rare, just because this is, as the applicant says, a threshold issue on whether they even need a variance or not. And they would have to pay the $1,200 regardless, if we decide that they did need one, and then they'd have to come right back before us to decide it on the merits. So
this is Katie Friddle. If I can make one more comment, and this just came to mind as you all were discussing the decision by the city of what's desired for this area. I just wanted to make clear that the height limitations, or well, at least the DTD2 ordinance predates Scenic River. So all of the requirements and regulations of that ordinance would have already been in place, and height restrictions would have already been implemented for the area prior to Scenic River going into place. So I don't know the history of the development of that overlay, and if there was a thought process that said we don't need a height restriction because there already is one. But I just wanted to make that clear. This is an area that's a struggle for us to interpret the language, so appreciate all of the input and guidance we can get from every direction on how to interpret that.
I understand that point, and I had the same thought, but other areas and other tables specifically give height requirements, minimum and maximum, and this one just says none. So that kind of led me to, just looking in context with other tables, that led me to think that it was intentional that they did not want a height requirement in this area.
Yeah, because they certainly could have. It would have been within their legislative authority to put whatever height minimum that they wanted at the time that the ordinance was adopted.
Well, and beyond that, they did in other areas. They
Sure.
did specifically say 3 stories here. I'm looking at table 13500.2, and it says 3 stories minimum height for a hotel and 2 stories for mixed use and things like that, which in statutory interpretation, that's an inference that the legislature could have added a height restriction or could have made it more specific, and intentionally chose not to because they put none.
Yes.
Board members, any questions, comments, or a motion?
I think Scenic River controls, so I think that means I move to sustain the appeal. I think Scenic River controls.
Okay.
A second.
Okay. We have a motion and a second to sustain or approve or affirm the appeal in case number 14771. Cast your votes, please.
I'm not getting a voting pane still.
Sounds like you were like me and you had a lot of windows open looking at the code.
Yeah, let me,
Maybe it's hidden somewhere, but
sorry. give me
Oh,
just-
weird. I got a pain.
Great. I know I messed up somewhere now. Oh, there it is. Sorry about that.
okay. And it's approved.
Thank you. If you stay to the end of the meeting, do you get to hear Mr. Voorhees play that guitar behind him?
Yeah, we've got a Zoom happy hour starting at 3 o'clock where he's going to play his top hits. So
We all get to love it. All right.
That's
Thank
a
you.
Jack Daniels guitar. I have no ability to play it, just display it.
We were worried we weren't going to be able to start on time, David.
All right, I'm going to jump off, let you guys get started. Thank you all very much.
all right, thank you. Okay, the next item was continued. So the next item on the agenda is additional items. Seeing none, communications and board reports. Does anyone have any? Okay, citizens to be heard. Is there anyone on the line that wanted to be heard? Is there any other business besides the concert that we're going to have here in a little bit? All right, sounds not. We are adjourned. Thank you, everyone.
Thanks.
Have a good holiday weekend, everybody.
You as well. Thank you.
Thank you, Kitty.